Now we have about 15 minutes left. I'm ready to ask a quick question to each of the panelists, but if anyone from the floor wishes to ask a question, by all means jump in. I'll put my quick questions very quickly. Firstly, to our first speaker, do you think that China and dispute settlement, its attitude is going to evolve, and if so, in what way? And in particular, do you think that the conciliation provisions of the convention might be more attractive to China than some of the other dispute settlement provisions? Then, for Dr. Jung, really the question I put when you finished, do you think the lack of detailed regulation of wind farms, for example, has led to real problems? Is there a serious problem that needs addressing, that we need to have a new conference, a new treaty on the subject, or is it something that is being managed all right in practice? Then for Professor LIAO, the two approaches to the methodology, doing it in two phases, within 200, beyond 200, or doing it in one single phase, as it were. Do you think that different approach has led to any differences in practice, or is it just a different way of reaching the same result? In other words, it's an interesting point you're making, but is it leading to a real differences in practice? And lastly, for Dr. Sender, could you say a word about the persistent objector and the customary international law of the sea, with a view to, for example, Turkey's attitude to the law of the sea convention, and what it might represent as customary international law if it reflected customary international law. So those are my questions, but as I said, if anyone from the floor wants to ask a question, or while they're thinking of it, I'll perhaps give it to each of our panelists in turn. Dr. Nong.
Thank you, Sir Michael. I think that you raised a very good question about Chinese attitude, involving attitude towards the dispute settlement mechanism on UNCLOS. I think there is I wouldn't say there's a misleading nowadays on Chinese attitude towards the Part 15 of UNCLOS. I think because compulsory dispute settlement is only the only option. So given that Chinese previous practices through, for instance, bilateral negotiation or maritime delimitation, for instance, between China and Vietnam in the Gulf of Tonkin, it's one of the examples that, but in terms of compulsory dispute settlement mechanisms, I think you're suggesting whether it's involving or not. If you only refer to the South China Sea arbitration award, I think there's a lot of consideration from Chinese political leaders' mind. And one of it is that it's not ready, because if we're referring back to like before 2013, there's a lot of discussion on bilateral basis and also multilateral basis between China and other claimant states. And it doesn't actually expect that the Philippines will bring this cause to a compulsory jurisdiction body. So, and then during the process of when China make its statement in 2012, I think explained very well why it questioned about the jurisdiction admissibility based on the full article that I mentioned earlier. And I think one of the major concerns is that from Chinese perspective, I think it's very concerned about states' consent is absent in this whole process. So in the future, I would say that when China, but you're also suggesting conciliation, I think there will be one of the options that China is more willing to consider. But as I'm also mentioned, China does not shut up the door of like going or accepting compulsory dispute settlement in the future. I think it has to be depending on case by case and also depending on the sincerity of the countries involved. But it's very interesting to know that I realized a couple of years ago there is among some law of the community in China, there is a discussion whether China is going to opt out of UNCLOS. I think that's a very dangerous discussion. I personally don't believe China will be working on that way. It will still be very much respect the Law of Sea Convention and making use, for instance, in other areas like fishing management and also navigation regime, etc. I think China will be very much depending on or respect the Law of Sea Convention. I think that's my understanding.
Thank you very much. Dr. Jung.
Thank you for your question. In fact, the reason that I started research on this issue is that there was an argument to adopt a new treaty to regulate offshore renewable energy activities, because the UNCLOS does not provide effective regulatory framework because it was adopted in 1982. However, as I explained, that I still believe that UNCLOS provides an effective regulatory framework, and because as a living instrument, there is a possibility to develop the detailed regulations within the existing legal framework. But I feel that at present, largely the regulations left to the coastal states' discretion, even though they have the obligation to adopt regulations, but the lack of standards or regulations can be just rely on the discretion of the coastal states. So that's why I think that the regional body can provide the effective forum to develop the detailed regulations. And it is slightly different issue, but it is also linked to the regulation. One of the main concerns of offshore renewable energy operations is how to compromise the conflicting interests with different activities in the maritime areas. Because, for example, in the North Sea, it is one of the busiest maritime areas, and not only renewable energy activities, but also shipping and oil and gas activities, and a lot of maritime activities are taking place in the same areas. So the governments try to adopt the marine spatial planning as a policy tool. So I believe that not only development of the regulations, but also to facilitate policies to compromise different conflicting interests would be necessary. Thank you.
Thank you very much. Professor Liao.
Yes, thank you, Sir Michael, for your question. I think to answer your questions, maybe I will take a step back to consider the reasons why, for example, in the Bangladesh-Myanmar case, ICLS opted for two phases of the exercises of delimitation methodology. I think a specific consideration in that case was that initially in the submissions of the parties, both parties denied each other a continental shelf beyond 200 nautical miles. For instance, Myanmar claimed for an equidistance line, and then the boundary line would end before it reached beyond the 200 nautical miles. So I think in the judgment of the Bangladesh-Myanmar case, ICLS first delimited maritime delimitation within 200 nautical miles, and then concluded that there was a possibility for the line to extend beyond 200 nautical miles, and then ICLS proceeded to consider the question of delimitation of the continental shelf beyond 200 nautical miles, including the issues on jurisdictional and admissibility issues. I guess that was a factor that to be taken into account in whether there was a one phase or one single exercise or two exercise of the methodology. However, I think it might not. I think the submissions of the parties are very important. They are, but it might not be decisive, because in the Somalia versus Kenya case, I think both parties requested a single line and same methodology throughout maritime delimitation within and beyond 200 miles. But the ICJ in that case refrained from taking into account the issue of the continental shelf beyond 200 nautical miles in the single exercise, but separated the exercise in two phases. Then as to whether it would lead to different results if we apply single exercise or two exercises, I think my answer would be yes and no. Yes, in the sense that if we look at the Bangladesh Myanmar case and the Somalia versus Kenya case, we had the impression that the maritime delimitation within 200 nautical miles has a dominating effect upon the entire delimitation methodology. It seems that the continental shelf beyond 200 nautical miles is simply an accessory in the delimitation process. And by doing that, I think the court or tribunal did not respond to some arguments raised by the parties directly related to the continental shelf beyond 200 nautical miles. And I think that would have influenced the delimitation process, but no, in the sense that I don't think in terms of the result, the delimitation would have been different, because the cases that the court and tribunals have been dealing with are concerned with adjacent states. So there, as I said in the presentation, there was a need to continue the line within and beyond 200 nautical miles. And I think in such a case, there was a quest for an overall equitable solution in maritime delimitation within and beyond 200 nautical miles. I don't think when the tribunals or the court, they delimit the maritime boundary within 200 nautical miles, they did not take into account the effect of such a line beyond 200 nautical miles. And I will recall, in fact, the Qatar versus Bahrain case, where the court decided to apply the methodology about territorial sea in the delimitation of territorial sea, and then apply the methodology about the single maritime delimitation of the continental shelf and the EEZ. But the ICJ emphasized that when it was carrying out its task in territorial sea delimitation, it had to bear in mind the ultimate task of the single line requested by the parties. I hope that my preliminary reactions are that's it. Thank you.
Thank you very much. Dr. Sender.
Well, thank you, Sir Michael, for that question. I suppose any careful lawyer will not address the specific circumstances of any case or state without carefully considering the facts. So I will take your question more generally, if I may, about the persistent objector rule, only to say that it is, of course, an established rule of international law, where the stringent conditions for it are met. That is, objection that is voiced before the rule comes into being, and of course, an objection that is consistently and persistently maintained. So to answer that question, the rule of the persistent objector applies across the board to all areas of customary international law, including the law of the sea. Of course, the only exception would be Hughes Kogan's rules. So I suppose the persistent objector will certainly apply and may well play a part in considering the legal situation in various law of the sea disputes. Thank you.
So you've carefully refrained from saying what Turkey's position is, so we'll leave it at that. Now we have about 2 or 3 minutes, so if anyone has a burning question from the floor, if the microphone can be given to Dr. Lando, please.
Thank you very much, Sir Michael. I have a question for Professor Xuexia. In your book, you focus a lot, I think it's chapter 4, on the question of establishing entitlement beyond 200 nautical miles. And one of the points that you make, which I find very interesting, is the difference between establishing entitlement when the relationship of the coasts is one of adjacency or oppositeness. And I was just wondering whether you think that that relationship also impacts the methodology for delimiting beyond 200 nautical miles. Thank you.
Please, Professor Lau.
Thank you, Professor Lando. I think I don't think the coastal relationship has a decisive role in determining the delimitation methodology, but perhaps more as a practical matter because, for example, between two opposite states, the establishment of the overlapping entitlements may be subject to more complexities. For instance, it could be easy if the parties share a common continental margin as recommended by the CLCS to Norway and Russia. And in that case, there was, I don't think that would be a very different exercise of delimitation methodology from the application of methodology in between opposite states within 200 nautical miles, such as between Libya or Malta. But I feel that the key issue if we're talking about the establishment of the overlapping entitlements, the key issue is how Article 76 or even the Statement of Understanding was applied to the specific case. Thank you.
Thank you very much. Unfortunately, that's all we have time for. So to speed things up, I'm going to hand the floor straight back to you for the final words. Thank you.
Thank you, sir, for moderating for the session, and thank you all the speakers, both on and offline, and also on the floor for participating in this session. So let us give a big round of applause for all the speakers.